Hey everybody, Todd Vandermeid, former NRA contract lobbyist here for another edition of Freedom Steel. So Monday we had oral arguments in the Barnett case, the challenge to Illinois' gun magazine parts ban and registration. So more on that after the intro. Hey everybody, Todd Vandermeid, former NRA contract lobbyist, Illinois gun law guru, the gun Santa or tactical Santa as I'm called on parts of the internet. So welcome back. I know it's been a hot minute since we've done some content, but hey, Monday we had oral arguments in the challenges coming out of Southern Illinois to Illinois semi-auto ban. This is where we prevailed in the district court and the state appealed up to the Seventh Circuit Court of Appeals. And it was an interesting show. I was actually in the courtroom for the entire hearing. So let's set the stage a little bit. We won in the lower court, the state appealed, and in between the time that they ruled on the injunction 2 years ago and earlier this summer, Judge Wood left the bench. So the panel that we had was Brennan, Easterbrook, and Wood. So now they had to replace Wood. As I believed and said all along, I thought this was going to be treated as a comeback case, that the three-judge panel we drew was not just a motions panel, that they were dealing with everything. And so that was in fact the case with the substitution of St. Eve, a Trump appointee. And so we were hopeful in the beginning of St. Eve being a Trump appointee, but she's been on the bad side of some 2A rulings, including a semi-auto ban in Viramontes and the Schoenthal, the mass transit ruling, which is a very, very dangerous ruling. So we were tempered going into the courtroom, and we kind of played our tactics figuring it was going to be a bit of a Donnybrook. If you go back and listen to the oral arguments last time, Judge Easterbrook was just a bully. He was a complete bully and a-hole and never let our side get a word in edgewise. And that's been his demeanor and persona, for a long time. So we really expected, with Wood not being there, that he would just continue on. Now, we kind of prepped for that, and figuring that he was going to sit there and pontificate and just be a bully. And that's not what happened. And so as we walk into this, they came into the courtroom, and the first thing I noticed was Judge Easterbrook is not wearing his age well. At 77 years old, you look him up on Wikipedia, that picture is not the same as the man I saw sitting on the courtroom. I won't go so far as to say he might be sickly, but he is not wearing his age well. So I don't know if that has any place in this, that is playing on the way he acted. It took him a full 17 minutes to ask a question. So right now, I ought to give it a little disclaimer. If you think this is going to be me picking apart the arguments in the context, wrong one. This is going to be a 30,000 foot overview of what I thought, what I saw happen in the courtroom, as if I were reading this from my lobbying days and testifying in front of a committee and all that. I will do a couple other videos and pick apart some of the questions and the state's answers and all that kind of stuff. But for now, I want to talk to you about what this looked like. So the state went first. And Judge Brennan, who was a little demure the last time we were there a couple of years ago, he came out swinging. He showed up to play, and he went after the state, and he was hard on them. And it was kind of interesting because at a certain point, so Brennan was on the left side of the court as you look at it from the audience. St. Eve was on the right side, and the two of them were peppering the state with questions back and forth. As I said, it took 17 minutes for Judge Easterbrook to interject and get in there. And, that was quite telling. And then we were waiting to see whether or not he was just going to crawl all over us when it was our turn. But again, so this was going on, and with it, the state kept trying to sit there and act as if they just automatically win. And they started by virtually saying that the lower court was just erroneous in the way they found things, and they did some things where they said, well, and the other side didn't put anything in about history. Not our job. They are completely trying to rewrite what the standard is and where the burden falls, and Brennan wasn't having any part of it. And when they got to when they were complaining about the facts, St. Eve pushed back, and it's like, well, you're asking us to throw out all, a 4-day trial. You're asking us to throw all this out. And Brennan referred to that this is the first case that's been before an appellate court with a record like this, with a trial, 250 exhibits, 16 to 18 expert witnesses, so on and so forth. So they were going in, and it seemed like the state got knocked off their game just a little bit. And when their typical arguments weren't resonating to where they had a couple of allies on there. And why do I think it took 17 minutes for Easterbrook to come in and ask a question? And why do I think he took kind of a demurred posture from where he was? I think Frank Easterbrook, walking into that courtroom, did not know if he had an ally on that court. I think when we went in on the PI and Wood was there, he knew he had an ally on the court. I think St. Eve, even though she's been on the wrong side of 4 rulings, it could be a swing vote. Now, I'm going to say, and I was asked by William Kirk over at Washington Gun Law, I did a live broadcast with him yesterday. I'll put the link to that one down below, as well as the interview I did with Greg Bishop. But I think that Brennan and Easterbrook were both playing to hook St. Eve. And I think what was going on was Easterbrook couldn't be a bully or possibly turn her off. And with that, Brennan kept going down about the record and how, well, isn't this a high hurdle for you, the state, to get over? And they kept saying, no, we don't think so, because we think we win either way. And with all that, that's what I saw going on from kind of a 30,000-foot view on this thing. And watching all this go on, I wonder if the Department of Justice, being in the room with Darheet Dillon, who I got to meet and got to offer up a little bit of ASC and Freedom Steel swag for her, some patches and stuff. Wonderful lady to meet. And she made a couple of good arguments. And the funny thing is, she looked Easterbrook stone cold in his eyes and said Beavis was wrong, that they got it wrong. And then when he tried to interject on her, he was not his typical bully self. He was pressing, but he wasn't the obnoxious a-hole he was a couple years ago. And so he asked her, well, if a court had ruled differently, would your position be the same? And she said, yeah, our position would be. And he goes, well, facts don't matter. He's notorious for putting words in lawyers' mouths that they didn't say. She's like, no, we just believe that these arms are covered under the Second Amendment, period. Full stop. And then she also called them out that their militaristic features test or usability was bullshit and in conflict with Supreme Court precedent. So there's a question. Now, here's the other parts that are interesting. There was a little bit of talk at the end about narrowing the scope of the injunction. Easterbrook, in his role, he had three different things he did during the hearing where he kept trying to play this gotcha law professor, trying to ding on a third-year law student to prove who the real intellect in the room was. It didn't go so well for him. And he got, well, you're not understanding my question. No, we understand your question. We just think it's bullshit. You know, that's what I would have said, but I'm not a lawyer. I don't practice in front of the Court of Appeals. So with this, we have a couple options. One, they could fine for us. That has its own ramifications. That means we are not in control of the case. If we win the whole thing outright, the chances are that the state will go en banc to try to get it reversed and drag this case out even longer. That's a decision. And I will put up here a little graph that looks at the current justices and how they were appointed. And the court does not look good for us going en banc. At best, I think we have 5 votes. At best. Now, our argument would be, why keep delaying this? Let's get this to the Supreme Court and see who's right. However, but there are worse alternatives for us. Judge Easterbrook was complaining that he didn't think the lower court answered the questions they set out in Bevis. And Erin Murphy, to her credit, she said, oh yeah, footnote 22, it's there. It just may not be in the format you like. So we had that. Then, so we could get a remand, and that will take time. And if Easterbrook's goal is just to drag this out and let something else get out there, that's the case. But I got the feeling he was throwing that out there to see if St. Eve was going to bite. And I don't think she bit on that because she commented about the record several times. So that's one thing. Another thing would be we get a split decision. They rule for us in part, they rule for the state in part. My bet would be the state will want to go en banc to try to get the win for us overturned. We will want to go to SCOTUS. Their en banc petition will trump our time to go to cert. We have to wait for that's done before we could go file our cert petition before the Supreme Court. And then from there, the one that kind of is the fastest for everything is if we lose. If we lose, then we're in control and we can go straight for a cert petition. And there's no reason for us to go en banc. I mean, with a possibility of 5 judges on there, I don't see it. I just don't see it. So with all that, where do we go? What's next? Their opinion. And their opinion will send us down one of those 4 roads. We lose, we go to SCOTUS. Remand, we're back to the trial court. We win, the state will more than likely go en banc, or it's a split decision, and then we're left hanging to see what happens if they take. Now, the Seventh Circuit Court of Appeals kind of discourages going en banc, but that's a argument for another day, seeing whatever they're going to do. So that is the 30,000 foot view of kind of like what went on. In my hot take on this, it's 50-50 is how we walked in there thinking we were going to get pummeled. We walked out of the courtroom with some hope. However, I'm thinking 50-50, but then I think I put my thumb on the scale that St. Eve hasn't been right with us on 4 decisions, Schoenthal, the mass transit case, being a really bad one. And in lieu of that, I don't know how she's going to break for us unless it's just she finds that the record met what was asked. These are factual findings she's not in a position to overturn, and she is therefore going to side with Michael Brennan, who wrote the dissent in the last one. So, as always, hey, like, copy, subscribe, paste the link around, do all that. Another shout out to Greg Bishop, who did an interview with me yesterday morning, and Bill Kirk over at Washington Gun Law. We had a really great conversation about all this and some of the things that went on in the courtroom, and I'll try to get some more stuff out to you about what's going on. But as always, frag out.